There are those who believe that the Supreme Court's decision is a landmark judgment as it puts a definite time frame on when sanction for prosecution must be given. There are others who feel that the courts have overreached and it's an unimplementable decision. Joining us now, he's smiling away to glory, Dr. Subramanian Swamy, man of the match as it were. He's come out, he's taken on the government, he's come out victorious. Thank you very much, sir, for joining us. I also want to introduce Vineet Narayan, senior journalist. It was his case that was cited in the Supreme Court. Thank you very much, sir. Aman Lekhi, senior advocate, has got some issues with the Supreme Court's decision today. We've also got with us Sudhir Kumar, former Commissioner of the Central Vigilance Commission. With us at this time, National Spokesperson for the BJP, Member of Parliament, Chandan Mitra. We've also got Sanjay Jha from HamaraCongress.com. I want to begin by understanding from Subramanian Swamy on what several people are saying is an overreach by the judiciary. They believe that you can't put a sword over the government and say that you must decide within 4 months. This is administratively very difficult to implement. That's what people have been ringing up various journalists, and that's the message the government wants to give this.
Well, it's not a new time limit. The Vineet Narayan case already has it. Justice Verma had said it, and this Chief Vigilance Commissioner has put it on his website, the guidelines for sanction, and he has said very clearly it should not take more than 3 months. This 4 months is that extra month in case you want to consult the Attorney General. I would think that, you see, first of all, let me say that nobody needs rarely more than 10 days to decide whether after all, what is the sanction for? To decide whether it is a prima facie case in the appreciation of the sanctioning authority. And he has to decide on the material presented. He has to do no inquiry at all. He has to not ask anybody. Now, in my case, of course, the Prime Minister sent it to Raja also to ask his opinion. He has sent it to the CBI and so on. So those are all not allowed under the rules for sanction. But the real question is that if you can't decide in 10 days, 4 months is a lot of time.
Sudhir Kumar has been with the Central Vigilance Commission. He feels that this decision is not implementable. Can you explain to viewers who would want decisions to be taken by the government immediately? 10 days, 4 months sounds like a reasonable period. Why do you, sir, with your experience, feel that the decision is not a good idea?
No, I don't say that it is not implementable. In fact, what Dr. Swamy has said, there are already instructions, guidelines there on record, but they are administrative guidelines suggesting that the cases must be decided within 3 to 4 months for according sanction of for prosecution by the competent authority. And there are also steps laid down for resolving issues if there is disagreement between the sanctioning authority and...
But that's clearly not working, because we have some figures over here.
Yes.
Of the 319 requests for sanction, or 126 requests,
yes,
sanction is awaited. So the government is sitting on the request for sanction. That's what Subramanian Swamy is being said, which is why this decision is being hailed across the country.
Yes, there are large number of cases which are pending this sanction. And it's very difficult to hold anybody accountable for that.
Aman Lekhi has some problems with the decision as well. Explain to our viewers what your problems are and why you think this could be a case of judicial overreach.
No, I will not say the case of judicial overreach. I mean, I'll qualify that. The question is that we have proceeding litigants like Mr. Swamy, who got activist judges. Why? Because we are responding to what is actually inept governance. Now, ideally, if the executive expedited whatever it's supposed to do theoretically, and the legislature was alive to the omission by the executive by having a law to deal with that particular omission, the occasion for the interference by the Supreme Court or court at all would not arise. But the courts are interfering because there is a failure insofar as the executive and legislature both are concerned. That said, while this judgment is absolutely unexceptionable in the facts and the political environment as it stands today, because the message has to go that corruption is something, it is intolerable. The issue is that when the judiciary starts laying down the law, now, while adjudicating a matter, it can be specific to the facts of the case. In this particular case, what happens is the issue of deemed sanction. The deemed sanction by its very nature deals with application of mind. Now, the problem with deemed sanction would be if in a particular case, the case is not one of sanction, but the person in charge wants to harass another official. In that event, he'll just sit on the file, and the person is actually liable to have the protection of law enforced, would by reason of deemed sanction be prosecuted. So that will actually negate the whole purpose behind.
Let me just quickly break that down. That's a theory that Mr. Lekhi is floating, the fact that there's a Babu who doesn't like someone against whom a complaint has been filed. Instead of rejecting that complaint, he sits on it, and after 4 months, it is considered to be deemed sanction, and therefore that complaint is investigated. We've got Vineet Narayan with us as well. Do you think that this could throw open the possibility of honest babus against whom there are complaints, or honest netas being hounded by litigants who have an axe to grind?
See, the current situation is such that permission is withheld. Litigants or the complainants are feeling frustrated, and this has been going on for decades. It's not something new with this government. It has been going on for decades. So some solution to this problem must come out. And as Aman rightly said, that when the executive fails, then the legislature, the judiciary has to intervene. But judiciary is not the answer to administrative functioning. I think now the direction is there for the parliament. When the Vinitha judgment came, they prepared the CVC bill, which was a very lopsided, very shallow bill. No teeth were given to CVC. To add salt to the injury, they brought the single directive back. So whatever little autonomy was left was also withdrawn.
Okay.
And as a result, corruption cases kept pending for years together. So I think this is high time Parliament should consider these guidelines. Parliament should consider the earlier judgment and should make a law, whether it is Prevention of Corruption Act or CVC Act, where such situation doesn't arise. People want to see result at the end.
So we're hearing a case which is being made that the judiciary is now laying down the law, which is not a good thing. Then there are others who believe that this is the way to go. The government cannot sit on complaints that it gets. But is this not a massive embarrassment for the government? I want to go across to Abhishek Manu Singhvi, national spokesperson for the Congress party. Dr. Singhvi, does this judgment not come as a slap in the face for the UPA government, especially the Prime Minister? For 16 months he sat on the complaint saying that the CBI is investigating, the case is being looked at. This seems to be another massive moral indictment for the Prime Minister's office.
I'm amused and shocked by the current fashion. It seems a media fashion to use 3 phases for every judgment which decides a legal point. One phrase is slap in the face, another phrase is indictment, another phrase is shocked. What has it held? It held 3 legal points. One, it has held that Mr. Swamy has locus. Second, it has held that you should decide a request for sanction expeditiously and within 4 months. And third, it has held that inquiries can start if you go to a magistrate without sanction. Now, this is a legal interpretation. What is a slap in the face? What is the indictment?
Okay.
Yes, it has gone against the interpretation of the Government of India. So, in any matter, 2 interpretations compete. One loses, one wins. But to consider it an indictment, has it held that somebody has committed theft? Has it held that somebody has committed murder? Has it held that somebody has done some travesty of truth? It's an interpretation.
You're saying,
please don't exaggerate and don't use such words.
You're saying, sir, that the media and the opposition is making heavy weather of this. This is neither a slap in the face nor an indictment, and most definitely not shocking. Let Chandan Mitra explain why he believes it's all of the above. Because the Prime Minister's office too has now on Twitter put out this comment. It says, we welcome the fact that both the learned judges have completely vindicated the Prime Minister while appreciating the onerous duties of his office. The government doesn't believe that this is a slap in the face. That's what the BJP has been saying, Mr.
Well, you see, I must say that I commend my friend Mr. Singhvi for keeping such a straight face and in fact managing even to smile when responding to this question. The fact is that the Congress seems to have adopted the principle that if you can't beat them, join them. So they have now started welcoming the Supreme Court judgment, which is actually, sorry Mr. Singhvi, which is a stinging indictment of the manner in which the government tried to hush up. I'm not going to more details. One case, the 2G case, in which CBI filed charge sheets against unnamed persons way back in 2008, where it was all known who were the culprits, where media reports continuously kind of exposed the deals that were going on, and then refused to give sanction to Dr. Swamy for prosecution of Mr. A. Raja and others in his department. So, having done that, the Supreme Court, having seen and observed the way the government dilly-dallied and tried to prevent any kind of prosecution, now the Supreme Court has come up with a 2-pronged thing. One, you don't need to anything. Any ordinary citizen can go and petition and an inquiry can start. That's one. And if the sanction is not given for prosecution within 4 months, it will be deemed to have been given. Now, these are absolutely landmark judgments that are emerging at the end of this entire range of scams that have dogged India in the last few years. And I think this is something which everybody will welcome. It has actually made every Indian empowered. It has made everybody into a Lokpal. I think we can all proudly wear a cap saying, "Main hu Lokpal," after this judgment. And I think people of India will be eternally grateful to the Supreme Court for empowering them in this manner.
You're blaming the Congress for trying to underplay the import of these decisions. Let me place some facts before Dr. Singhvi. On the 29th of November 2008, Subramanian Swamy wrote to the Prime Minister seeking sanction to prosecute Raja for the 2G spectrum scandal. The Prime Minister did not reply till the 19th of March 2010, kept sitting on the file for 16 months. And when he replied, he said that any sanction at this stage would be premature since the CBI was investigating the matter. Now the Supreme Court says all you have is 4 months. In that you have to give sanction or it will be considered deemed sanction. Is this not, sir, a direct indictment of the Prime Minister for sitting on the complaint in the 2G case?
This is again a distortion. The concept of delay is if you judge it and measure it against an established norm. For the last 60 years, there is no norm established of time that you have to give sanction for a minister's prosecution in X months. 4 months is decided for the first time by this judgment. Henceforth, after this judgment, you are absolutely right. You must do it in 4 months. But prior to this judgment, for minister's prosecution, for minister's sanction, no time limit was fixed. And therefore, different governments, not only Congress but non-Congress governments, have taken varying periods of time. You have taken 6 months in one case, I have taken 1 year in one case, the third person has taken 18 months. It's just that Mr. Swamy has looked at this case. So therefore, this time limit has come into being now. So there is no concept of delay prior to this because there was no time limit.
Okay, Vineet Narayan wants to come in and respond to what you're saying.
Mr. Singhvi, the time limit was given in Vineet Narayan judgment. It's a different matter that NDA did not take that into cognizance and prepared a bill which did not have those provisions. But time limit was given.
And also, Dr. Subramanian Swamy, the fact that there is no norm and therefore there is no delay and therefore this sounds like the most convoluted explanation you can come up with.
Well, let me also say that at the time I sent this letter and then later on went to the Supreme Court, what did Kapil Sibal, Salman Khurshid and others say? Who is Swamy to write a letter? Why should the Prime Minister take notice of everybody and anybody? So the Supreme Court has given them a smack on that. Said that every Indian citizen has a right, constitutional right to make a complaint. Second thing is that they say the Supreme Court made it very clear that the Prime Minister has to decide on his own. Of course, they have said that he should get good advice from his officials, so the PMO has been indicted. Now, the fact of the matter is that the Supreme Court has gone one step forward, said that you don't need now to go and get sanctioned to go to the magistrate for an inquiry. On the contrary, Mr. Sibal and Mr. Salman Khurshid said, Swamy has come rushing to the Supreme Court. He should have gone to a magistrate and got an FIR. Now, obviously, now the Supreme Court has made it clear that this was there. Now it is a constitutional right, and so the Supreme Court has empowered the public. In all ways, it is a blow for the Congress party, which had delayed. Now, the Prime Minister, of course, I have never held him culpable criminally, and therefore the Supreme Court judgment clearing him, I fully endorse. But as far as these advisors are concerned, the legal eagles, they are the ones who should go back to law school and learn some law.
You're demanding that Kapil Sibal and Salman Khurshid go back to law school because they questioned Dr. Swamy's right to go to the Supreme Court, saying he should have gone to a magistrate instead. The Supreme Court coming down hard on the government, and that is an embarrassment regardless of what Dr. Abhishek Manu Singhvi might try to say on the show.
Rahul.
Rahul, the first thing that we need to understand is that there is a benchmark that Abhishek Singhvi talked about that wasn't existing before. The second part and the more critical part is that at this point of time there has been no allegation per se against anybody in the government for having deliberately tried to sabotage the process. So the intent is not under question at all. And to just kind of assume that and to assume that the delay has been done willfully is, I think, just mere idle speculation. And to what Chandan mentioned, let me just be very categorical here. The change in telecom policies was started by NDA in the late 1990s when it actually changed it from the license fee to the revenue share, which actually began the whole controversial issue about how the government should either raise telecom revenue or look at increasing the subscriber base, which in fact is the same issue on which the pricing of the spectrum became controversial in the mid-2000s that we're talking about. But, the one other point I would like to mention, that the Lokpal bill per se, which the government has actually passed in the Lok Sabha, that the parliament has actually passed in the Lok Sabha, incorporates the fact that you may not and you do not need any kind of sanction for investigation or prosecution of a public servant who has done something which requires to be...
So let Chandan Mitra respond to that. That's the case that all Congress spokespeople are making, that this is what the Lokpal Bill 2 provides for, and therefore this is not an embarrassment for the government, because we too are keen on ensuring that there is no permission required for sanctioning investigation.
No, we all know that under what circumstances the Lokpal Bill came in, and with what great reluctance the Congress brought it in, and how they deliberately conspired to see to it that it does not get passed in the Rajya Sabha. So let us not go into that part of the...
These are very lame accusations. I don't think they hold water. Chandan, it is the BJP that did not get passed in the Rajya Sabha. Actually, you would have had a law by now.
No. Sorry, your ally, the Trinamool Congress, didn't get passed. So let's not talk about that, and let's not go into that. And now let's go back to, how the world started with a big bang or a whimper as to this revenue sharing spectrum and all that. Though all that is past, we are in the instant issue of this massive loot of the national exchequer by minister or ministers in the full knowledge and right under the nose of the Prime Minister, in which even ministers of the government have warned against going ahead with this kind of a scheme. And now, I think after observing the whole thing, the Supreme Court has decided that there must be some directive, there must be some legal power to enforce. Because they assumed, the court so far assumed, the response to Mr. Singhvi's point, that delay was not issue, was never an issue. Because they assumed that government will act in good faith. But when governments act in bad faith, then I think there is no option but for the courts to lay down and prescribe certain things. Supreme Court has done well to say this. And as for Dr. Swamy saying that some ministers should go back to the law school, more than law school, I think if there is a school for morality, they should all go there and learn some morality before they assume office as ministers. Because as ministers, when your minister, Mr. Kapil Sibal, says there was zero loss in telecom, I think it was more than a legal issue, it was a moral issue. How can a minister with a straight face make a preposterous claim like that?
Let me get in a legal perspective as well, Mr. Lekhi. Is this or is this not a massive legal and moral indictment of the government?
You can say yes to it. Why? Because the question is sanction. Sanction comes from the PMO and the indifferent source of the PMO. And the issue is very critical here, which we have to address, that if there is delay, then the reason for the delay can be complicity. And if the reason for delay is complicity, the withholding of sanction is something which can be said to be not wanting in bona fides altogether. Now this is the issue which we have to deal. Now when you deal with the sanctioning authority, the Supreme Court should also have dealt with this particular issue, much like the deemed sanction. If a person withholds or delays sanction, then the withholding or delay of sanction, the existing scheme of things will in some way delay the prosecution. Now if the prosecution is going to be delayed, there has to be some motive behind delaying the sanction altogether. Now what will happen to the person who has unreasonably delayed the grant of the sanction? Would that person not be equally liable to the person against whom the sanction is given? Because you'll be throwing the person against whom prosecution is being initiated and make him face the prosecution. What about the person who has tried to, in some way, shelter that particular person from delaying the prosecution?
And that's the charge, Dr. Singhvi. The opposition continuously levels on the Prime Minister that he wasn't proactive enough in checking A. Raja while he was unleashing the 2G scam. The BJP accuses your government of shielding the corrupt, and therefore isn't this verdict an endorsement of what the opposition has been saying all this while?
I think you are repeating the same question. Inaction, delay. The delay is the same. There is no delay if there is no norm fixed. The norm of 4 months has been born today. Therefore, delay cannot be for the last 60 years of government. But more important, the BJP has to answer, which they are not answering, is that our report on the Lokpal, for the first time in independent India, more than 3 months ago, specifically abolished all sanctions. Section 19 sanctions, Section 6A sanctions, Section 197 sanctions, all abolished. On the basis of our report, a bill was brought which was carried through Lok Sabha with great difficulty and opposition from the BJP. Thereafter, it could not be carried through the Rajya Sabha because the numbers are not with us.
No.
So the BJP is to answer that are they for retaining sanction at all?
Don't give wrong facts.
If they are not for retaining sanction, why did they not join us for passing the bill in the Rajya Sabha? It is the BJP which has obstructed the non-grant, the non-abolition of the requirement of sanction.
Chandan Mitra wants to
Now,
respond to you.
if the root clause doesn't remain, then where will be the requirement for all this sanction? We had abolished sanction. It's only the BJP which is retaining it.
Mr. Mitra.
Misleading people. I'm afraid he is deliberately and knowingly misleading. He knows that the issue was on the appointment of Lokayukt in state. BJP's opposition was only to that. It was nothing to do with Lokpal. BJP said, we are fully in favor of the Lokpal, we are in favor of the official Lokpal bill, but we oppose giving that constitutional status because that was not relevant and necessary. And on the question of Lokayukt, we believe that the states should be empowered to frame their own Lokpals under a model piece of legislation. We never oppose the Lokpal. So don't say that. We have fully supported Anna Hazare's movement and the demand for a strong and effective Lokpal, which you have tried to dilute.
Vinit Narayan wants to come in. Yes.
See, it's very disturbing that on an issue of corruption, where every common citizen feels very concerned, political parties try to take mileage against each other. They want to score points against. I want to remind you, Rahul, that in Hawala case, the CBI officials, DIGs and IGs and joint directors who criminally connived with the accused, intentionally delayed the investigation, suppressed the evidence, concealed the evidence to be put in the court, were not only protected by the successive government, both Narasimha Rao and Atal Bihari Vajpayee, but they were suitably rewarded with presidential medal and foreign posting and all that.
Okay.
So, I mean, this has been going on. So, I don't think any political party can
You're saying neither party can claim the high moral ground.
Yes.
Before we end this discussion, I want to quickly shift our attention to what might happen in court today. There's an action-packed day today. Tomorrow there's a strong possibility that the case for seeking prosecution against P. Chidambaram, the Home Minister, that could come up. Justice Singhvi is retiring on the 2nd of February. Justice Ganguly is retiring on the 2nd of February. He wants to finish this off before he goes. That's the sense. You're smiling all the way. Do you think Chidambaram is going to be able to sleep tonight?
Well, first of all, what I've asked for in the Supreme Court is CBI prosecution of Chidambaram, not prosecution, CBI investigation of Mr. Chidambaram. The prosecution I'm doing in a separate petition in a separate complaint in the trial court. That's a different matter altogether. That order will come on the 4th. Here I'm asking for assistance from the CBI, and therefore I want the CBI to prosecute. I would say that the material I brought on record is enough to convict Mr. Chidambaram. So therefore I'm expecting a very favorable order from the Supreme Court.
I want a legal perspective from Mr. Lekhi as well. We've seen what happened in the court today. The court seemed to be in a very belligerent anti-corruption mode. Even doing what some people consider judicial overreach, as you said, laying down the law, which should ideally be laid down by the parliament. Given that, how strong do you think, as an expert, is the evidence against Mr. Chidambaram?
No, that will be prejudging a verdict, which I don't want to do. If the evidence is strong, a prima facie view is all that is required, because investigation doesn't necessarily require proof for conviction. So as long as it's a case which requires scrutiny and inquiry, then obviously if the court is convinced that these matters do require investigation, and it is in public interest that investigation is made of anything involving corruption, then obviously the Supreme Court will not shy away, and the Supreme Court has not shied away from dealing these particular issues. And whatever is appropriate in the circumstances, what Mr. Swamy is saying is correct. The matter requires inquiry, investigation. I'm sure Mr. Chidambaram will also welcome it, because that will be the best way to clear his name and basically show that the accusation being made is unfounded. So if the investigation is true and the Supreme Court feels that it is warranted, then it would be the best way to settle the controversy altogether.
Mr. Kumar, if there's an adverse order or observation against the Home Minister, do you think, opposition will definitely gun for his blood, but do you think it will make his stay as Home Minister untenable?
That's very difficult for me to say. But I would say that if there is an unfavorable order, the CBI investigation should be set into motion. and an objective investigation should be carried out.
Well, we could be back with a similar panel tomorrow evening as well, looking at the court's verdict order on Dr. Swamy's plea against P. Chidambaram. An action-packed day lining up for us in the Supreme Court tomorrow. For the moment, to all my guests for joining us for the center stage debate, thank you very much.